Welcome back to this course on copyright and related rights law. In the previous sessions, we were discussing infringement. We have understood that Section 51 provides for certain acts which will be considered as infringement. We have also understood with a detailed understanding of the Supreme Court decision in R.G. Anand versus Delux films on infringement not being limited to literal copy but also extending to non-literal copy. In this particular session, we are going to focus on infringement in connection to torrent websites, which is one way of online piracy, and we will also look at certain other aspects which are connected to infringement, such as jurisdiction and offenses. Let us consider a torrent website like Kick-Ass Torrent or 1337X. What these torrent sites do is that they provide to a user who is accessing this torrent website with the facility to download copies of films, sound recordings, books. The problem is that the copies that are being downloaded are unauthorized copies. Clearly, this is something which will be struck under Section 51. But what is the role of the torrent client in this? Say the torrent client is Kick-Ass Torrent. What is their role in this infringement, and can they be considered as infringers themselves? To understand this better, let us understand how torrenting is working. Unlike traditional forms of file sharing, where the file is stored on the platform. For example, if you were to upload a file onto YouTube, it will be stored on their server. But nothing is stored on the torrent website's server. Torrenting, on the other hand, uses the power of its users. If a user, for instance, selects a particular film and its copy for the purpose of download, the torrent client will contact a tracker. A tracker is a specialized server which will then check the other units or the other nodes where such a download is happening or has happened. It, in effect, splits a large file into small pieces and simultaneously it allows for an exchange of this information between these nodes. So the user is connected to various other nodes or various other computers where such a download is taking place, and as and when the downloading is happening with respect to the user who is downloading that file, he is also exchanging that particular information to whoever is downloading it. Thus, there is a simultaneous exchange of data that is happening between peers. This is the reason why torrenting is referred to as a peer-to-peer file sharing system. If you look at it in terms of efficiency, it is an incredibly efficient method of file sharing. But when the file sharing is of pirated copies, it is a serious issue for copyright holders. So much so that many movies which are released even in the last few weeks, you would note, have faced issues with leaking, and such a leakage is found on torrent websites apart from other mediums. Let us then see how the issue of violation of copyright is attached to such torrenting sites. The Delhi High Court, in a case that involved UTV software communication and others versus torrenting sites like 1337X, considered the application of Section 51, Clause A, Subclause 1. The court said that defendants' websites, which are communicating the films to the public by making the films available for being seen or heard or enjoyed through their websites, are infringing the plaintiff's copyright in the film. We had understood that Section 51, Clause A, Subclause 1 is effectively a broad right that encompasses violation of the exclusive right that is provided under Section 40. One of the rights that is provided to cinematograph film authors or the producers is the right to communicate the film to the public. In enabling such a communication of pirated copies, the torrenting website can be caught under the net of 51 Clause A, Subclause 1. We had discussed that under Section 51 Clause A, Subclause 2, there is an exception that if the person can show that he was not aware, then simply because he was providing a platform for communication of the work for profit, he could not be held to be an infringer. Let us compare a website like YouTube with a website like 1337X. The legitimate activity that is happening on YouTube far outweighs the illegitimate activity. Nobody is contesting that there isn't infringing material available on YouTube. There is. But as we had discussed, technological advancement and the impossibility for a platform such as YouTube to strike every single case of violation as and when it occurs makes them justified to claim the exception under 51 Clause A, Subclause 2. But can 1337X claim such an exception? The illegitimate activity happening on these websites far outweighs any legitimate activity that is happening there. What about the application of the exception under Section 52? Let us see what 52 Clause 1 Subclause C is saying. It says, certain acts not to be infringement of copyright. The following acts shall not constitute an infringement of copyright, namely, transient or incidental storage of a work or performance for the purpose of providing electronic links, access or integration, where such links, access or integration has not been expressly prohibited by the right holder unless the person responsible is aware or has reasonable grounds for believing that such storage is of an infringing copy. It then says that once awareness has been brought on account of a notice that is provided by the right holder, then there must be a takedown and it needs to be kept down until there is an order from the court. If there is no such order for a particular period as provided, which is 21 days, then such access can be provided. But the issue with 52 clause 1 subclause C is that it is talking about transient or incidental storage. But there is no storage that is happening with respect to a torrent website. As we have understood, the connection is rather between two peers and more peers, and not really any kind of storage happening with respect to the torrent client. Therefore, the code says that the defendant websites are liable for copyright infringement under 51, and they cannot claim the exception under 52 clause 1 subclause C because they are not entities that are transiently and incidentally storing any work. The next topic that we will touch upon briefly is the topic of jurisdiction. Jurisdiction is a broad area in itself in terms of its understanding. There is only one facet of that which I am touching on for our discussion, such that foundational understanding of jurisdiction with respect to copyright specifically is understood to an extent. The primary provision that we must look to is section 20 of the Civil Procedure Code. Under this, a suit for infringement can be filed either at the place where the defendant is residing or carrying on business, or where the cause of action arises. But when we look to section 62 of the Indian Copyright Act, it allows for the plaintiff who is claiming that his work has been infringed to bring such suit where he is voluntarily residing or carrying on business. In terms of what section 62 is then doing, is adding an additional layer of forum for jurisdiction. Let us see the objective behind such an additional forum being added by the Copyright Act. In Doda House versus S.K. Mengi, the Indian Supreme Court referred to the objects and reasons for the Copyright Act 1957, and it said that these objects and reasons show that such an additional forum was created to enable authors to file the suit for violation of the copyright at a place where they reside. The court further explains that considering the first aspect of the aforesaid principle, the common law which was existing before the provisions of law were passed was Section 20 of the Code of Civil Procedure. It did not provide for the plaintiff to institute a suit except in accordance with the provisions contained in Section 20. The defect in existing law was inconvenience or deterrence caused to the authors suffering from financial constraints on account of having to vindicate their intellectual property rights at a place far away from their residence or the place of their business. The Supreme Court is explaining that where an author of a work is faced with infringement of his work, would he be deterred from filing an infringement suit if he was told that he can only file such infringement suit where the defendant is residing or carrying on business, or where the cause of action has arisen? Or can he rather bring such a suit where he is residing? According to the Supreme Court, Section 20 and its restriction on forum of jurisdiction was a kind of a mischief that provided for such a deterrence effect. And in order to remedy it, Section 62 of the Copyright Act brought in this additional forum. Let us move ahead to the point concerning offences. Under Section 63, it is provided that a person who knowingly infringes or abets the infringement will have committed the offence of copyright violation. The punishment for this offence is stated within Section 63. An exception that Section 63 makes with respect to a particular right provided within the Copyright Act is Section 53A. This particular provision is talking about the resale share right. You would recall the resale share right is the right which the artist of a painting, for example, will claim over subsequent sale. It is provided in Section 63 that if a person is knowingly infringing copyright but not doing it for gain, then noting the adequate consideration which emerges in such a circumstance, the court can grant a lesser punishment. Let us also look to another provision under the Copyright Act. This is Section 64, which authorizes the police to seize infringing copies without a warrant. Let us take a look at this provision. It is saying, any police officer not below the rank of a sub-inspector may, if he is satisfied that an offence under Section 63 in respect of the infringement of copyright in any work is being or is likely to be committed, seize without warrant all copies of the work and all plates used for the purposes of making infringing copies of the work wherever found, and all copies and plates so seized shall, as soon as practicable, be produced before a magistrate. You can see here that there is a particular rank of police officer who alone can conduct such a seizure. Let us see a case wherein a police officer below the rank of sub-inspector had conducted seizure. In this case of Nawaz versus State of Kerala, the court had considered such a seizure as amounting to vitiation of the trial. This is how the court explained it. When a statute prescribes a particular mandate for conducting seizure by designating the officers with their rank, it is a safeguard made by the law-making authority for protection of the accused so as to avoid illegal search and seizure at the instance of officers of lower rank. So the seizure by the assistant SI of police who is lower in rank to the SI violates Section 64, and therefore such an action will vitiate the entire trial. Let us also consider how the non-identification of violation of what kind of work can lead to non-holding of any infringement and in turn an offence. Such a situation arose in this case of Irfan versus State of Uttarakhand, in which two individuals were nabbed by the police who were selling CDs. These CDs purportedly carrying film content were seized by the police, and the individuals were charged under Section 63. Interestingly, at no point did the authorities run the CDs to see what work was contained within these CDs, because there was no such identification of the work or which author was being affected in terms of any such violation. The court had to consider that there was no infringement. What the court had stated is that copyright has an age. It is not that the copyright may remain in perpetuity. First and foremost, the prosecution has to show and establish as some work was infringed and infringed copies were sold. With that, we are ending our discussion on infringements. I hope these issues have been well understood. In the next session, we are going to take a look at what subconscious copying is and whether that amounts to infringement. And we will start with the first part of problem solving. Thank you for joining me. See you all in the next session. Thank you.